Good afternoon, everyone. It is officially afternoon where I am, but good morning if you happen to be in a different time zone. My name is Greg Jacobson. I am the secretary of the Georgia Bar Construction Section. Thank you all so much for coming to the CLE today. I'm just going to talk for a minute, then I'll hand it over to our wonderful panelists. This CLE is part of the Georgia Bar Construction Sections and Atlanta Bar Construction Sections Construction Law 101 series. It's a 15-part CLE series that's going to cover a range of topics. It's designed to be a crash course in construction law taught by the state's leading construction law practitioners. Everyone will learn about all the essential elements of being a well-rounded construction lawyer, which is a very good thing. Just a few upcoming events. First, we have two more Construction Law 101 CLEs coming up over the next few weeks. One on October 27th regarding anatomy of a construction project and key players. Another on November 19th regarding introduction to construction claim damages. The next Atlanta Bar Construction Section breakfast meeting is on October 29th regarding battle stories, how to be a successful construction associate. And finally, the Georgia Bar Construction Section's way too early holiday party is November 12th here at King and Spalding. So finally, let me get into introducing today's speakers. J.D. Howard recently joined Barnes & Thornburg as a partner from Morris, Manning & Martin. His practice primarily consists of assisting owners and developers with the drafting and negotiation of design, consulting, and construction contracts. JD has represented clients on projects that range anywhere from small tenant build-outs to the recently completed Arthur M. Blank Children's Hospital, as well as high-end multifamily developments, large-scale industrial warehouses, and several golf courses thrown in for good measure. I hope you got to play them for free or at least at a discount after. Joey Maxwell has been at Sterling Seacrest Pritchard for the last decade, and he is one of the partners who leads their construction practice. His practice consists of assisting construction companies and real estate developers with their insurance, risk management, and surety bond programs. He's active in numerous construction trade associations, including Associated Builders and Contractors, Associated General Contractors, and Construction Financial Management Association, where he currently serves as the Georgia chapter president. Well, I'm very much looking forward to this, so I'm going to stop talking and let these two take it over. Thanks, guys.
Thanks, Greg. Joey, you want to hit the ground running? Any thoughts to add before we get going?
Yeah, no, very much appreciate. I've gotten the opportunity to speak to the Bar Association several times, and always appreciate the opportunity to be invited back and speak to this distinguished group. Hopefully one day, I told JD, I was like, I'm really just angling to get, we're getting AI note taker. I'm sure there's a policy on that somewhere in here, to a group of lawyers. I'm really just angling to get parking access down near the Mercedes-Benz Stadium here at one point. But if you want to go ahead and advance the slide. As we've talked about and as Greg introduced, we're going to go back to school here, do key concepts in insurance 101. So hopefully through the next hour, JD and I say at least something relevant that maybe one of you guys scribbles down as we go through this. But so let's kind of go over, if we go to syllabus here, like what are we going to do today? So we're going to understand the role of insurance in construction and how to evaluate the insurance needs for a given project. We are absolutely going to avoid the question of what insurance limits are appropriate, because that's always impossible to answer. But it's kind of an overarching theme of what we're going to go through and what we're going to look at. And the thing to remember as a practitioner of law in the construction realm is that your job is to overview and look at this as like a big jigsaw puzzle. That's really all insurance is you're trying to help your client assess and view from a 360-degree view, what is the picture they are trying to put together? Because every one of these policies we're going to go through, every one of these indemnity clauses we're going to go through, all fits together towards whatever specific project that you are building towards. And that's kind of the theme of what we're talking about. Is it's a puzzle, and remember that no two construction projects are the same thing. We're working in an imperfect system with imperfect people, and these are all human developed and human built projects and properties. And so there's always going to be something that you are having to work around and assess, whether it be site conditions, whether it be new general contractors, new scopes, new verticals, whatever we're going to try and do. So keep that in mind as we kind of go through this puzzle piece. We're going to consider basic insurance requirements, and then we're going to talk about what to look out for when claims arise. All right, 101, evaluating risk. So here's where I'm going to nerd out and go on my romantic journey about insurance.
Clearly a broker.
Clearly, I'm not going to sell you anything during this during this presentation today. Role of insurance in construction. So remember that there's a high risk of loss in construction projects, and my theme here to talk about here is that insurance fosters commerce. The thing to remember: every single one of us can bemoan insurance companies. I have my own gripes with them. Everyone has frustrations with them. But none of these projects for your clients and prospects would happen without insurance backing them, right? There is a need to method to allocate the risk of loss that can happen. And the thing to remember as you're assessing all these programs and policies you put together is this is all just one big episode of Murphy's Law, right? Anything that can happen will happen. And I always joke when I see those farmers commercials on TV, there's a reason they're putting these things like those aren't scripts, those are actual claims that have taken place. So just remember that as a backdrop of insurance fosters commerce. Nobody would engage in any of these projects if they didn't believe that they had a way to hold a party responsible for damages or anything that they caused. So I kind of highlight that with my bullet point there of insurance increases project success rate, and often claims only get resolved by insurance. And what we're doing really is just hedging against the other party's insolvency.
And that kind of gets to like, well, where do we start? We were laughing before the program started that when you start to put this thing together and you're staring at a blank screen, it's like, I don't even know. This is such a broad topic. Where do I get going? Where does the rubber meet the road? As a construction attorney, I think the first step when you're talking about evaluating construction insurance needs are, what's the project's risk profile? How do you figure out, is this a risky project? Do I need a lot of insurance to backstop all of these risks that my project's facing? Or is this kind of run of the mill? Everybody knows what they're doing. Pretty low likelihood that something goes wrong. To begin sort of breaking that down, I've kind of got a couple considerations up on the screen. You need to make sure you know who the parties are. Is there an architect involved? Are there several engineers? What about subcontractors? Who's the GC? Do you have relationships with all these people? Or is it kind of a first time dealing with some of the folks that are involved? On top of just knowing who the parties are, you need to know what's going on. Is this a specialty build out? Are you renovating a historic hotel? Are you building something brand new on green, clean dirt? You don't have to worry about pre-existing histories, and it's a tilt-up, warehouse space, so there's not a whole lot of risk involved with the scope of work. You got plenty of time to do it, plenty of money, then you probably don't need as much insurance to backstop everything. Once you kind of have a grasp on who's doing what, understand if there's any special concerns about the scope of work being performed or the project being constructed. You've called Joey over here, got the broker on board, got his opinion as to what insurance products may meet your need. You also need to try to match insurance to the risks posed by the parties involved. And last case scenario, insurance doesn't cover everything. So you need to make sure that your construction contract with all of these different parties is tailored to assign risk to the party best in place to control that risk. Sometimes that's insurance, sometimes that's the other players in the game. So talking about the other players in the game, who are the most typical relevant parties in a construction contract or in a construction project? Typically, you've got an owner at the top. There may be a lender involved there. Owner's going to enter into direct contracts with an architect and other design professionals to get the base building design hopefully squared away. You're also going to contract with several consultants to do due diligence on the property that's being developed, on the site that's being developed. You'll then eventually, once the design and all of that is hopefully firmly in place, everything's done properly, you onboard a contractor, and the contractor is going to subcontract out to folks actually doing the work. There may be any number of design build subcontractors that are also responsible for designing a system and constructing it. That's a separate sort of risk. They're also going to contract with suppliers who pose their own risks. These may be the parties that are involved, but getting a good idea of who's playing the game, not just like the category they fall into, like if you're dealing with a Home Depot versus a specialty supplier, does help give you a better understanding of what risk do they pose? Are they a going concern? Hopefully Home Depot's not going to disappear overnight and leave you stranded, but other small specialty suppliers might. What do you do if something bad happens?
I think one thing to highlight as we're kind of working through this too is if you go back to that slide real quickly, is that this graph, actually the first one we started with was way more complicated than this. So we tried to simplify it down to all the different parties that are involved. But the thing to remember is you're drafting these contracts, right? And before insurance is getting involved, hopefully it never comes to actually having to go back and look at that breakout section. But it's important to realize that many years ago, the AIA broke out the insurance section of the contract into its own separate exhibit, right? Because it was getting glossed over and there were disputes happening because all these people that are on this chart, right, are all friends at the beginning of the project and everyone's there. It's going to be great. We're going to build this building. We're going to renovate this space. Everyone's going to be happy at the end of it. But you guys are lawyers and you guys wouldn't have jobs if people actually got along all the time, right? And so making sure that all these different pieces put together work harmoniously together and that the insurance responds in the manner that it should to each person is important. And JD was highlighting it too, of just, obviously you're looking out for your client's interest, but the way to make this system work is to try your best to make these contracts equitable to who the parties who need to be held responsible. Because more often than not, I feel like I get contracts in my office that are basically one-way loaded guns. And that's not a great way to start off any relationship.
Just waiting for the trigger to be pulled. And Joey makes a good point too. We'll get sort of into the contract considerations later on in the presentation, but too oftentimes you see the AIA industry standard forms break out insurance into a separate exhibit for GC contracts. They're built into like architect contracts. So many times those things don't get filled out. They don't actually become part of the contract. So we'll kind of cover all those concerns later on in the process. But the takeaway from all of this is insurance should be way more than an afterthought. It's something that you need to address upfront when you're onboarding everyone. Get in front of your broker, get in front of your risk management team, make sure that you have at least sketched out the type of project you're going to build, who you're going to involve, and you've got a plan for how you're going to ensure the risks posed by that project. So that kind of transitions to our next piece. What are some common risks that the different players pose? Mostly from the design side, as an owner or as someone who is getting a tenant maybe who's getting a project built for them, you're primarily concerned about design defects from the design professionals. If they fail to do their job a certain way, how do you address that risk? But there are other risks that go along that maybe you don't think about, like, what happens if my architect runs over a subcontractor on their way into the job to do a site inspection? Is there the insurance that covers their defective design risk also going to cover that risk? Probably not. You need to make sure that you're matching the type of insurance product that you're requiring each party to maintain to the risks that they pose. What happens if my design professional doesn't pay any subcontractors or subconsultants? Is there an insurance product out there that covers that risk? Do I need to address it contractually? All of this stuff is part of the jigsaw puzzle that we're trying to put together, hopefully on the front end instead of the back end when stuff goes south.
And thinking through, the defective design, it's relatively rare that you see a full-on professional liability claim in my world, but when they are, right, everything can grind to a halt. It's always interesting, right? Because I've got a claim right now of a design professional claim. I've got a design build general contractor, has architects in-house, and they subcontracted the design for the structural engineering out on about a $60 million project. Well, highly qualified firm, highly reputable, everything should be great. And we looked at these contracts 2.5 years ago, and thank goodness we designed the insurance and indemnification correctly, because originally the indemnification clause that we got back from this design professional said, hey, if we screw up, you have to indemnify us. And obviously, that's not an equitable transfer of risk. We flipped that back around. What's happened now is they misdesigned the load calculations on the structural steel. Concrete contractors out there trying to hang panels from the steel bends and doesn't hold the load anymore. Project is stalled. And obviously now we're getting insurance involved. But You think about these things, like I said, as Murphy's Law, like these things can never happen, right? Like people are good at what they do, but we're dealing with imperfect systems and people make mistakes. And so making sure that you do have, especially on design professionals, I'm going to harp on this a lot today. Design professionals are notorious for carrying incredibly low insurance limits for the values of the projects that they are building.
And the same applies to contractors, but we're in talking about not the incredibly low limits, but thinking about all the risks that they pose and maybe not understanding that the risks that these parties pose exceed beyond what you typically would be worried about, like on a contractor where you're worried about defective construction. They have the same sort of, even more so, site safety concerns. Shout out to my dad for a second. My dad's a building inspector, was a building inspector in a small town, tripped and fell on a site and shattered his elbow. What happens when it's something that's beyond your control? A third party wanders onto your site, gets hurt. Do you have insurance that covers that? Do you need insurance to cover that? That's kind of some of the considerations that you have to keep in mind on the planning end, before things hit the fan and go south. So part of adding value as a construction attorney during this process is helping your clients think outside the box. If you represent owners, think about the risks posed beyond just defective construction, defective design, all the different ways that something could go south. Mention that to your client, develop a plan. If you work on the contractor side, similar, like you have to guard against risks that you're maybe liable to the owner for issues that arise during the project, and also guard against risk that your subs may pose to you. So a lot of different puzzle pieces, the whole thing's moving around. How do we figure out how to put it all together? And that goes back to like, well, who the heck's in charge of putting together the puzzle in the first place? Generally speaking, owner side folks, although the owner may be dealing with lender requirements, equity partner requirements that need to get factored in. What we usually see is if the contract's coming from the owner side, the insurance is dictated up front. You set minimum coverage limits, certain types of coverage that a contractor, architect, consultant has to maintain, and then you negotiate from there. The factors that you're considering are kind of listed on the screen. Which party is in the best place to cover the risk? Who can match the insurance with the type of risk at the lowest rate, I guess, like what insurance is available to which party, and then what's the project delivery method? Are there any third-party insurance requirements that we touched on a little bit earlier? Whether it's joint venture partners, equity partners, lenders. If you're building something for a third party, if the tenant has any requirements, or if you're a landlord, something along those lines. But all of these are considerations that you can't just set it and forget it. You set it, it's the beginning of a conversation, and then the project unfolds from there.
And I think going back just one real quickly too, as we consider who sets the insurance requirements, an axiom that I try and operate off of is just showing evidence of the limit is not the same as having coverage, right? More often than not, I see just a big set of limits, and people will approach me and they say, hey, I need $1 million here, $10 million for this. But the contract doesn't define what should that insurance actually be covering. And a joke I've said to clients before, if you open up the back of the Atlanta Business Chronicle, for instance, and go to the classified section where you see all the lawsuits that have been filed in the court system that week, half the things in there are people suing their insurance company for coverage that they thought that they had.
So just to interrupt you, that is why Joey is critical to the process. You got to involve your broker, you got to involve your risk management team. Make sure that everybody's on the same page, that what you're saying is what is actually reflected in the policy, and everyone understands this is what's going to be required. This is what we've got. Here's what it does.
Yes. So I do not think there is such a thing as over communicating when it comes to insurance, in terms of what you expect to be covered in a contract. Because the thing to remember about insurance too, and that people often forget, we call it a policy, but really it's just a contract, right? I know I'm saying that to a bunch of people who went to law school, but you need to remember that it's 300-page policy, right? And the first 2 pages of that policy/contract are going to say what it's covering, and the next 298 pages are going to say how they're trying to not cover what they're trying to provide you. A good example of this that I've had come up about 6 months ago, I had a client who's building a multifamily building. They were going to be using EFIS stucco on the side of it, and they hired an EFIS subcontractor. So I told them, before you start that guy, send me a copy of his policy. Because I guarantee you, because it was some new person, it was a guy with a pickup truck and a dream, who had bought an insurance policy from the general, probably off TV. And I was like, I guarantee you that policy is going to exclude EFIS coverage. And they send it over to me. Policy excludes EFIS coverage. My client's befuddled. He goes, why would they do that? And I was like, this is America. Like we don't
Expect somebody to make a rational choice.
exactly. I was like, your insurance company is going to provide you a policy they never have to provide coverage on. Of course they're going to do that. So unfortunately in this business, and you guys are well aware in the legal profession, the devil is very much in the details. And one thing that I think that gets glossed over a little bit, we don't deal with it as much here in Georgia, but especially if you're going down towards Florida to pay attention to, making sure you're over communicating, spelling out, is carrier financial ratings. I think the last time I did this presentation last year, in Florida, there were 11 insurance companies who had gone out of business since 2017, and about 5 of those had just been in the last year. So we're setting insurance requirements because you may not need them right now today for an incident that may take place today. You may need these coverages down the road, and we'll kind of go through what you're asking for in those coverages as we kind of progress through the presentation.
And I think, just to kind of sum up this slide and the concept, who sets the insurance requirements? Really everybody. It's, akin to coming up with a game plan for a football game. Head coach may have some input, your coordinators may have some input, your veteran players may have some input. The important piece is to get everybody around the table and talking. Like Joey was saying earlier, there is no such thing as too much communication when it comes to insurance, when it comes to drafting contracts. Make sure that we've got everybody on the same page and we know exactly how we're going to move forward.
All right, so keys to evaluating and controlling coverage. I had here in my notes that JD was going to discuss an ironclad answer on limits.
There's no such thing as enough limits, right? The answer is either it depends or too little.
No, but the sufficient limits line, when I'm talking to clients, for instance, we're trying to start with 2 items, right? Like assessing what's the size of the project and what's really the risk, which is, kind of quantifiable by somewhat of the contract value and maybe benchmarking against some sort of claims data. And you can usually ask brokers for that type of data and or the carriers of like, what are some kind of typical project limits for these type and sizes of projects. But something to consider too is, if we're talking about a client for yourself that maybe does smaller projects more regularly, and they're asking how much coverage that they should have, I'm always also just looking at, all right, what's the size of the balance sheet here, right? Like, what do we don't want to get to the end of the rope here, have a big claim and have less insurance than we have cash on the balance sheet. That's usually a bad omen. But a stat that I kind of keep in the back of my head when considering limits, especially even for smaller projects, is the average wrongful death claim in Georgia is $10 million. So, it's a good idea to set a standard set of requirements, but as we kind of keep harping on, right, like you need to adjust those based on the actual project. And as I said before too, the next bullet point, getting evidence that the insurance requirement is actually in place. Evidence of coverage and evidence of a limit is not actually having coverage. So I'm going to go back and forth between this slide and the next slide real quickly. This next slide's probably too small. Let's see. All right, it's not that small. So this is the thing that everybody asks for. Everybody wants a certificate of liability insurance, a COI. And then they want to get that and they want to put it in their file and they want to go home. And what we've been doing a lot of education over the last several years, and especially the insurance commissioner, particularly in the state of Georgia, has cracked down heavily on, is that very first sentence at the very top of that certificate. And it's always amazing to me, no matter how sophisticated the contractor, how many people will read this for the very first time, is this certificate is a matter of information only and confers no rights upon the certificate holder.
That's the trick of the trade, right? You put something in bold and at the top of a document and no one actually reads it.
So he says to a group of lawyers again. So this is what most people are asking for. And more than that, people are going to say, I just want the certificate, and especially banks and lenders. They want this certificate, and then they want down in that description of operations box, they want it to say, I'm an additional insured, and I ask for all these endorsements, et cetera, et cetera, et cetera. The reason this is being cracked down on so heavily, especially in the state of Georgia, is that for many years, people in my world were just putting information into that box saying, oh, Barnes and Thornburg is an additional insured on this project. And then there was actually no endorsement or language in the policy that would reflect that. And so people would come down to make a claim, step down as an additional insured to make a claim on a policy and find out that they had no rights to that policy. And they come back and say, well, the certificate said it. Well, it doesn't mean anything. Well, you can go into, maybe that's a broker E&O issue at some point, right? But at that point, you're already frustrated. So the piece that has to come with the certificate of liability insurance is getting copies of declarations pages, right? Because nowhere on this, that EFIS subcontractor that I mentioned before, my example, you're going to get something that says commercial general liability. Cool. They've got $1 million limit. I'm good. It's not going to say on here that EFIS is excluded from this guy's policy. So you need to get a copy of the declarations pages, and then which is going to show all of the different endorsements. And then as we kind of go through this, we'll talk about additional insured language as well. You're going to want copies of those endorsements as well, showing where the language is in the policy that matches up to what you're requesting in the contract, right? Because the insurance policy is only going to be triggered by whatever that contract says. So if you don't ask for it in the contract, even if I have it, you may not have a right to it. So this is my soapbox I stand on a lot, is this one sheet of paper gets so many people into trouble.
Yeah, and just to kind of ad lib on that a little bit, the COI is just an evidence of coverage that's in place at that moment in time. There's nothing saying that I didn't go out immediately after I issued that COI and canceled all these policies. So it is critically important that you don't just get a COI. You have the contractual terms and conditions obligating whoever you got the COI from to do the things that you wanted to see reflected on the COI. If you want to be an additional insured, it's not enough to be listed as an additional insured on that description box. You have to have the contractual requirement obligating the person to list you as an additional insured, and then you have to get the evidence of the endorsement that it actually did take place to satisfy the concern. Do you need to go back? Are we good to go?
No, I said I was going to go back and forth. I didn't do it. All right. 101, you graduated. Now to insurance 102, and what you're going to have to listen to me talk about specific insurance products here for the next few minutes. All right. Standard coverages for construction insurance products. I always like to start with the main central one that we work off of here, which is the CGL policy, commercial general liability policy. What it's addressing is third-party bodily injury and property damage that you cause to somebody else. And this is kind of the thing I talk about when trying to think about what insurance do I need. I like to start with CGL policies. You're trying to learn insurance and what am I asking for, what's covered, is that statement I said, third-party bodily injury or property damage that I cause to somebody else is incredibly broad, right? But every single one of you knows on my second bullet point that a CGL policy isn't going to cover if I wreck my car and hit JD's car. My automobile liability policy is going to cause that. That's third-party bodily injury property damage. But one of the first things that's excluded from a CGL policy is automobile liability. So a good place to start as you're trying to think about this puzzle that you're putting together is, let me look at my CGL policy. What's excluding out of that? What is the insurance company saying they're not covering here? And it doesn't mean that it can't be covered. It just means it's more appropriately meant to be covered somewhere else. So when we're thinking about CGL policies, you're basing it off two things: premises liability, so stuff that's going to happen on a job site, right? A crazy claim example I have that didn't turn out to be a claim, thank God. Premises liability, client 5 or 6 years ago was building a 6-story condo building in a very dense urban area. Big windstorm comes along, piece of plywood flies off the top of it, and it lands in the playground of a daycare. That would have been a premises claim. It was not recess time, thank God. And then the more important piece that you're more often making sure you're checking carrier financial ratings, you want to be making sure you're additional insured on. The part that you're making sure kind of that it has this run out piece is making sure that you have what's called products and completed operations coverage, right? That's where you're coming back for construction defect. And more often than not, you're focusing that on usually building envelope contractors, your masonry, your glaziers, your roofers, things where you're going to see water intrusion, because that water intrusion isn't going to show up day one after substantial completion. It's going to show up 4 years, 5 years from now, where suddenly you've got latent defects in the building.
The day after the warranty burns off.
The day after the warranty burns off, right? So we'll talk through different specifics on the GL as we go through. I'm probably kind of jumping a little bit too much forward. Automobile liability, a little bit self-explanatory around that one. Excess and umbrella liability. Excess and umbrella liability traditionally is just going to sit over top of your liability coverages. So automobile liability, general liability, and then we can go through a piece called part of workers' compensation called employer's liability that can sit over top of. It can sit over top of more things than that, but most traditionally, that's what you're going to see it over top of. So you may come in and say, hey, I want $10 million worth of general liability. No one's going to give you a $10 million general liability policy. You're going to say, here's my general liability policy, and here's my excess liability policy that's going to combine and satisfy whatever you're asking for contractually.
And when you say sit over top of, what you're saying, just to make sure that we're
Yeah,
covering
sorry.
the building blocks, is once you exhaust the 1 million per occurrence, 2 million in the aggregate of CGL coverage, then the excess umbrella kicks in 10, 8, whatever the heck.
Yes, thank you for the fair point. And we'll kind of go through what I mean by sit over top of. It's probably too loose of a term. As we go dive deeper into the CGL policy in 103. Workers' compensation is meant to, for instance, Georgia is a sole exclusive remedy state. So for workplace injuries, so workers' compensation should cover any worker that is on a job site. One thing to pay attention to, because I know I don't have a slide on workers' compensation, when we talk about premises liability claims, making sure that your owner or general contractor, or whomever contractor is protected. A favorite thing to do for people to get around workers' compensation rules is that it is state mandated that you have it if you have 3 employees or more. So therefore, there is a state marketplace for workers' compensation. Obviously, you can imagine it is prohibitively expensive. For instance, like if a roofer has to go get coverage through the state marketplace, it costs 125% of their payroll, usually for that coverage. That's not very affordable. So people go in, they buy a policy, and they either cancel the next day after they evidence their coverage to you, or more importantly, they exclude themselves if they're an owner operator from that policy, so their payroll is not calculated for premium. If they are excluded and they get injured, that claim goes upstream. Workers' comp is trying to find and attach it. A work comp injury is trying to find and attach itself to the next living thing, essentially. It's like a parasite. It is going to swim its way upstream until it finds an active workers' compensation policy, even if that person excluded themselves from it.
No comment on its relation to the insurance industry writ large.
No, it's not a parasite, right? But if you consider the legal advertising industry, who's putting their face on these billboards, there are a lot of really successful people that have figured out a way to navigate that system around workers' compensation. And then builder's risk, we'll dive more specifically into this as we kind of keep going. It's a first-party property coverage meant to cover property during the course of construction.
And that's an important part that we'll get to in a little bit later. Builder's risk typically is the insurance recovery vehicle of choice for damages during construction. And then you have CGL for post-construction, which we talked about a little bit, but that's a question for 103. Other specialized coverages that we may not have like very deep dive specific pieces on here. You'll see owner's protective professional liability indemnity, or OPPI for less of a mouthful. This is kind of going back to the piece where I say design professionals are notorious. I'm not beating up my architect brethren, but are notorious for carrying relatively low limits for projects. And so an owner's protected professional liability indemnity is a policy that's designed to set excess to whatever the design professional's insurance is in those regards. Pollution and environmental. The note I have to make here is that pollution environmental is much broader than you will typically think it is. You're dealing with chemicals and hazardous waste, right? That kind of picture kind of paints itself for you. But interesting claim I had many years ago was a civil. The case I like to use is an environmental claim was a civil contractor moving dirt on the side of a road. Big rainstorm comes along, which never happens in the Southeast, blows out the silt fence and washes out the job site. All that dirt and silt runs into a nearby creek, and that nearby creek ends into a very expensive cove in Lake Burton. So all that silt runoff was then a pollution condition inside that cove of a bunch of people who were not happy to wake up and see really muddy waters outside of their window. That's not something you think about in your brain as like being an environmental and pollution condition, but that's going to be excluded from your general liability policy typically as a pollution condition. So that's where I say, again, you try and think through, all right, it's not covered here. Where is it going to be covered?
Inland marine and equipment coverage, this is going to pair. It's, one of those fun insurance terms where inland marine makes no sense to say out loud. But basically it's for property that's not stationary, right? Like property that's moving all the time. So that's where you're talking about people's equipment, stored materials, all those different things that are going to go into a job site. This is one of those things too. People working in downtown Atlanta, I mean, I've had bulldozers get stolen, which still not sure how that happens. How somebody backs up and steals a bulldozer, but making sure that your client has proper coverage for the equipment and materials that are going to be on a job site through these types of coverages. A good example, we talked about defining site security provisions in a contract earlier, was last year during the major winter storm that happened here. Big industrial site, kind of out in a rural area. We have very limited site security because we're thinking this is out in the middle of nowhere. Freeze comes in, nobody's really manning the job site. Somebody backed in and stole $200,000 worth of one of my roofer's materials that day because they had all day out there by themselves. And that came into a large dispute between a subcontractor and a general contractor for the general contractor's failure to maintain site security conditions. And my client, the roofer, was going to have to file insurance claims on themselves on it. So it was trying to paint who's responsible. So it can be even things just like, right, like who steals roofing material? A lot of people apparently. I'm going to jump down and come back to SDI because that's going to be a larger topic here for a second. Aviation, in every general liability policy, you're going to see that it's going to exclude, aviation or drone related claims. You can have a claim where I had a cease and desist letter years ago because one of my clients was flying a drone over a project site. Big wind blew it over a HLN CNN producer or anchor's house, and so that was a liability claim potentially. Something that is often, and we won't talk about too deeply in this presentation today, but does not get addressed enough in contracts is cyber. When you have contracting parties together, most of the time, those are some of the most frequently, trying to think of the correct word for it, right? But there are a ton of transactions taking place between parties in a construction project, right? Of payments going back and forth all the time. And so it is rife with cyber claims and social engineering fraud claims that take place. And it's happened several times where it's stalled out a project. I had one 3 or 4 years ago where, somebody hacks into the general contractor, impersonates the general contractor to the owner miswires. This particular instance was $1.2 million out to a fraudulent third party. Project gets stalled because suddenly nobody has cyber insurance for that claim, because even if the general contractor had cyber insurance, they weren't the ones who paid the money out fraudulently. They weren't the ones who made the mistake necessarily. And so now the project's stalled because the owner is lacking funds and the general contractor is filing suit against them because they're still owed $1.2 million. So it's one of those things people don't think about necessarily that can stall a construction project, but miswired payments and social engineering fraud can have a major effect on construction projects. We'll have a section on wrap-up policies a little bit later. Sub-default insurance. I should move the slide closer to bonds because we talk about them as somewhat interchangeable, even though they're not. Sub-default insurance is a two-party agreement whereby the general contractor is basically replacing the bond company. We'll go into what bonds are a little bit later in the presentation, but essentially they're stepping in and saying, I'm going to manage the default risk of this sub internally myself, and then I'm buying insurance policy, basically reinsurance in this instance, which is insurance for insurance. If you want to think about how that cycle goes, above whatever that is. So the example I usually use, right, if I'm going to buy $5 million subcontractor default insurance policy, I'm going to be doing all the pre-qualification that my bond company would have been doing previously on all these subs. And then I'm going to take the risk of that default. That risk might be the first $500,000, $1 million plus of a default claim that I might be paying out of pocket. Then an insurance company is going to step in and help participate in paying that claim in various different ways up to that limit. And the reason why you see this as such a prevalent piece in the industry right now is because most major large general contractors are really insurance companies that happen to build things nowadays. And we can kind of go through that. But this is becoming prevalent because if you can, for a general contractor, if they can manage the default risk, they're still paying, the owner's still paying for the risk mitigation called 1 to 1.2% of the contract value of bonds or sub-default, because the general contractor is incurring costs, right? And running and managing the risk of these programs. But those policies cost significantly less than that 1.2%. And so the general contractor's ability to manage that risk creates a profit center for them. And so that is why you are seeing the growth of SDI become highly prevalent in the industry.
All right, so I'm sure everybody's eyes have already rolled over. But let me make sure that we get there. If we haven't gotten there for you already, what is CGL? Commercial general liability. We talked about it a little bit earlier. Typically covers an occurrence causing injury to a person or property and is not subject to an exclusion. First lesson of the day was insurance agreements or contracts, 2 pages of here's what's covered, a million more pages following that saying what's not covered. Start at the basics. What is an occurrence? Typically an accident. It means something happened, right? As opposed to the opposite is a claim. When you sue somebody, when you pursue recovery for something, more specifically, an occurrence is typically defined as an accident including continuous or repeated exposure to substantially the same general harmful conditions. A whole lot of nothing just means something happened. And that something has to have caused bodily injury or property damage. That's important to remember. This isn't, a lot of people tried to make CGL claims when COVID happened, right? But there was no actual bodily injury, no property damage for COVID shutting down your project. There has to be actual damages to a person or real property. Going back a little bit, another important thing about occurrence is that something has to have happened. It's not necessarily that. The important part of it being a occurrence-based policy is that it doesn't matter whether or not the claim was made in the same policy year. It just matters that the thing happened in that policy year. So if you had CGL coverage on 12/31, but you didn't get around to actually making the claim until January 2nd, the appropriate policy is the policy that was in place on 12/31 when the occurrence took place. So that's a distinction between occurrence-based policies and claims-based policies. And an important thing to keep in mind when you're talking about, okay, I've got the CGL policy. What does it cover? Who do I look to when something actually bad happens? So we talked about occurrence, causing injury to a person or to property. That gets a little bit tricky. We talked about it at a really high level, just introducing the types of policies and products that are available. If there's a builder's risk policy in effect, you're more likely than not going to turn to that builder's risk policy instead of a CGL policy during the course of construction. So another thing to keep in mind is you've got to have damage to person or property. Does it mean defective work is automatically covered by my CGL policy? Not exactly. It's not cut and dry like that. What happens if your CGL policy is triggered? Those are the next kind of bullet points on the slide. The insured gets a defense from the insurer. So your insurance company steps up to the plate and should provide an attorney. If you don't have one, there's distinctions in every policy. Maybe you get to pick your own attorney, but you're obligated to a defense, and that arises when the claim is made, when you're actually being sued. It doesn't mean that you have to have been found liable for the damage that happens. First dollar defense, meaning the minute you get sued, you should be able to go to your insurer and say, hey, this is covered by my CGL policy. I need someone to defend me, and they'll take care of it from there. There's also a duty to indemnify you that should be part of the CGL policy itself. That is triggered when you're actually found responsible for the personal injury or property damage that occurred. So a lot of moving pieces, a lot of things to keep in mind, but high level overview, that's what CGL is. That's what an insurer does when you have a covered claim. They provide a defense And then should you actually be responsible, they're responsible for paying the cost associated with that.
Like a few of the major exclusions to kind of watch out for. This is not all encompassing list, disclaimer. But residential, earth movement. There's a big one you'll see that insurance companies will slap on grading and civil contractors, what's referred to as XCEU, which is explosion, collapse, and underground. Once again, why would somebody sell a policy that doesn't cover anything, Joey? Unclear. But you'll see that a lot, and you have to think about it in terms of, I've got an electrician I'm looking at right now. That's a prospect of mine where they have XCU excluded in their policy. No big deal. It's an electrician. They dig trenches in the ground to lay conduit and wire, so they could cause damage. And one thing that JD has highlighted here at the bottom is defense costs may deplete dollar limits of coverage. A piece to really pay attention to comes into play a lot more professional liability policies, but you will see it on general liability policies. Is calling people call them wasting limits. We refer to them as defense inside or defense outside the limit. So you want your client or to be requesting in their contracts that their contractors have defense outside the limits of liability, which means that the defense cost that gets paid for does not deplete the dollar limits of coverage. As you all know, right, the defense costs may actually outweigh the actual damages. So you do not want those depleting your limits to where you no longer have coverage left at the end of a lawsuit. Builder's risk insurance. So this is talking for this is buildings and structures under the course of construction, right? It is meant to cover property while it's under the course of construction. And property policy specifically is not going to cover while it's being built. But if we're thinking about while it's under the course of construction, we're insuring for not just the building or the renovation of the materials they're putting themselves, but we're insuring them for their offsite storage where they are otherwise. So the big piece of why people lean on this coverage, and sorry, I was jumping around my notes, which is why I was kind of all over the place for a moment. The big piece why I'll focus on this coverage is because it is a no-fault coverage. And so unlike a liability claim, when it's filed, during a course of construction policy, we do not have to do nearly the level of investigation to find fault for a policy to pay out, right? More often than not, the big claims that we see for builder's risk always tend to be sprinkler or water or pipe related, right? So, somebody's coming in and installing a sprinkler head, water floods out the building. We've got to come back and rebuild. This is a great place of not trying to define who's responsible for that. Pieces to pay attention to when you are negotiating these is who are the parties involved is important to who's responsible for the deductible. If you're representing a general contractor that, a middle market company, but they're working for Home Depot plays on a much larger playing field than does the general contractor. That client may be agreeing to a contract that says, hey, you're responsible for the first $200,000 of the deductible on the builder's risk. Well, that's a much different equation for Home Depot than it is for your middle market contractor. So paying attention to that. And then a new thing that I've added into this presentation since we did it last year is that it is very important if an owner wants to schedule and seek coverages for things that are beyond the hard cost limit of construction and wants to file a claim for soft costs, especially potential loss of rents. There was a court case that just got handed down on appeal that started about 10 years ago this year that's been very interesting to look at, where travelers did not pay for the loss of rents for an owner, even though it was scheduled on the policy. So in this particular claim happens, damage happens to a building from a failed retaining wall. Owner files a claim for loss of site please. I'll have to find it. I apologize, Bruce. I will find it and I will make sure somebody sends it out. But in this particular instance, retaining wall fails. Owner goes and files a claim as an additional named insured on the policy, not the first named insured on the policy, for their loss of rents. Travelers thinks, yep, we're definitely going to pay this claim, fronts a bunch of money to the owner for the loss of rents, and then 6 months later comes back and claws it back and says, oh, nope, we're actually denying it, because they ended up stating that the additional named insured on the policy, which was the owner, because the general contractor bought the policy and then scheduled the owner, did not have the same rights as the first named insured under the policy. due to some you and yours language that was within it. I will find the case and send it out to those who want it. But it was,
Long story short, it is more important than ever with that
Yes.
kind of case law on the books to make sure that an owner's purchasing the policy, or you're jumping through all the hoops with your broker, with your risk management team, to make sure that there is no set of circumstances that an insurance company can find to wiggle out of an otherwise valid claim.
yes. And in that case, you know, the appeals court basically said, like, we know this doesn't make sense because they paid premium for coverage. And they're not paying it, but this is what the policy is, and that's what we have to live by here. So I'm pushing a lot to say, hey, you know, a lot of owners push down the builder's risk to the general contractor, but you may not be getting the coverage that you think you're getting
Right.
when you're buying it via the general contractor. Professional liability. Who needs to carry? Everyone. Basically. So I spend a lot of time talking to most general contractors and subs as well too, of saying basically in today's world with how much BIM modeling that there is, how many contractors do constructability reviews, value engineering, guarantees on lead certifications, all of those things can be professional liability claims. Just because you are not stamping drawings does not mean that you do not need professional liability coverage for an error or omission. So this is going to cover economic and financial damage that you cause to somebody else. And so does not necessarily require a bodily injury or property damage trigger. This is one of the big ones where we talked about wasting limits, of making sure that you are providing defense costs outside the limits of liability. And that's something very important to pay attention to, especially when it's coming to your architects and engineers and consultants. Because if you can imagine, if I move the defense cost inside the limits, it will make my policy and renewal cheaper than if I'm paying premium for coverage outside of it. So there's the economic incentive for someone in your contractual chain to buy less coverage unless you stipulate what they have to carry. On there, I've got tail coverage too. So this is one of those parts that is a claims made rather than occurrence. So occurrence-based policy, right? If I'm with Travelers in 2020 and I'm with Liberty Mutual today and an occurrence took place in 2020, I'm going back and filing the claim against Travelers. Differently, if I was with Traveler in 2020, I moved to Liberty today, there's what's called, and what needs to be paid attention to, it's called a retroactive date on professional liability policies. This states what point the coverage is going to be picked up by the insurance carrier going forward. So your contract provisions need to state that the retroactive date on whatever professional liability policy being provided, it starts before the actual project takes place. Because as soon as I leave Travelers and go to Liberty, Travelers is completely off that coverage. Liberty Mutual is going to pick up whatever retroactive date I had. Let's say I started my business in 2015. The policy is going to say claim, you know, retroactive date 2015, some odd date forward. And that needs to be picked up and paid attention to. Otherwise, there will be no coverage.
That's a wrap, folks.
Yeah, thank you for the pun. And actually go back to the professional liability one time for me. Something very important to pay attention to in writing into your contracts too, I apologize, I missed my note, was making sure that you're writing that the definition of professional services for whomever you are contracting to includes whatever scope of services they are providing. I just finished reviewing for a prospect of mine a 50-page professional liability policy, in which their definition of professional services was basically nullified by one word in that policy, to where they didn't have coverage. This was for a owner's rep construction manager. So it's very interesting. So paying attention to that definition of professional services. It's a wrap. Thank you for the pun. Wrap-up policies that you'll see regularly need to be addressed differently than your other traditional insurance policies. A wrap-up policy is going, or a controlled insurance program, you'll see the terms OCIP or CCIP. So it's owner controlled insurance program or contractor controlled insurance program. They're designed to provide a singular source of coverage for all or most project participants. So where you see them on single projects are usually super large mega projects, where, you know, somebody wants to make sure they have continuity of coverage for two different things: general liability typically, and workers' compensation, and making sure that everybody has streamlined coverages. More often than not, where you're seeing these more frequently outside of the mega project space is anything that kind of sniffs or might become residential. The reason for that is because there are a lot of triggers in all these policies, as I've mentioned, where insurance companies do not enjoy or like residential exposure, usually because they have a tendency to lead to large class action lawsuits for construction defect down the road and for what people are on the hook for. So enter owner control insurance program or contractor control insurance program, whereby everyone's going to say, for my general liability and workers' comp coverage on this project, I'm going to exclude this project from those policies, and I'm going to essentially sign up for one specific project-specific policy, which I'm going to enroll in, and everyone's going to be covered for that particular instance. These policies are one time usually for the most part, what you'll normally see, and they're going to cover through the statute of repose for construction defect in whatever state you're operating in. So Georgia, that's 8 years. In Georgia, most of these are designed to cover the construction defect on the general liability for 8 years. And so there's usually cost savings when you have these big projects or these residential ones where you're avoiding coverage gaps, and they can result in cost savings because you're kind of using an economies of scale to purchase these projects. Like I'm saying, most of the time they're single, but when you have really large owners or really large contractors, you will see what are referred to as rolling programs. The more infamous one in the city, right, is the airport has a rolling OSIP program that you have to enroll in if you want to work down at the airport. So they're enrolling you into their insurance. And so you have to deduct the cost of your insurance out of your bid proposal for whatever you're providing. That was very quick and dirty.
Yeah, and sorry, I realize we're getting close to running out of time. For anyone that knows us, we can talk a whole lot, especially about insurance stuff. So let me blaze through a couple of contractual provisions to keep in mind. As we were talking about earlier, kind of the most important takeaway from this is ensuring that insurance terms are covered in your contract, and you've got the right contractual hooks to start the process and requiring whoever you're contracting with to make sure they have insurance. First order of business, require insurance. It is amazing how many times construction contracts, particularly AIA forms, get signed up with little to no required insurance, no mention of policies that must be maintained, no description of coverage, no nothing, because the insurance stuff gets broken out into a separate exhibit that was supposed to draw more attention. Instead, an owner signs up 101, 102 and doesn't pay attention to the 201 or other stuff that's supposed to be included with it. Therefore, the insurance stuff never gets filled out and nobody knows if there's any insurance available for the project. Another huge consideration, requiring people to maintain insurance after completion of the project. Like we were talking about earlier, your risks don't end at substantial completion. So many latent defects arise 4 or 5 years after, well after the warranty period has expired. What are you going to do? Make an insurance claim. Oops, my insurance has expired. I didn't renew it. All these things. You need to have a contractual hook clearly stating that, hey, everyone's going to maintain insurance through the statute of repose in the place where the project's located. You're going to provide me evidence of coverage yearly, and we're all going to float merrily along and hope a claim doesn't arise.
So it's going to happen.
Yeah. Another huge consideration, making sure that you have all the relevant parties listed as additional insured. If you're on the owner side, you want not just the SPE that entered into the contract, you want any holding companies, any subsidiaries, anybody involved in the organizational structure of that entity listed as an additional insured. If you're, any number of different entities removed from the chain, and you aren't an additional insured, God forbid something wild and crazy happens, like architect runs over a subcontractor sues everybody involved in the project and discovers, oh, there's this holding company that wasn't an additional insured. Maybe I should just sue them because they've got the deep pockets. Even though you should have had CGL coverage, auto coverage, umbrella coverage to hopefully address the risk. Maybe they find somebody that's outside the coverage for that policy.
Insurers are becoming much more stringent on who they'll allow to be named as additional insureds,
Right.
or what they will respond to. At least most additional insured forms that are published by the Insurance Services Office now focus on people who have privity to contract.
Right. Okay. Last kind of catch-all. Here's some additional considerations to keep in mind. making sure that you get notified if there's material changes to policy limits or policies get expired. That kind of defeats the old, hey, I'm gonna buy up insurance, send you a COI, and then cancel it the next day. Address your SDI or bonding requirements in the terms of the construction contract itself. And if you're using a wrap policy like we talked about, make sure that you're covering the enrollment process, how claims get made, and you clarify as well, do you have to maintain CGL policy outside of the wrap for things that happen offsite that may be covered? Or like, are you satisfied with covering the risk just through the OSIP CSIP policy? Again, really quickly, what happens when things go south? People, by and large, just shoot a claim at a million different policies and are surprised, hope to find that maybe one of them responds, but are surprised to find that an insurer just didn't respond to anything. You didn't have the right insurance in place. How do you go about making a correct claim against the correct policy? First, you have to figure out the facts, identify the relevant policies, match the policy to the harm that occurred. Like we were talking about earlier, you're not going to make a claim that should be covered by an auto policy to a CGL policy. You're not going to make a claim that should be covered by a builder's risk policy to a professional liability policy. You have to match the coverage to the harm that's occurred. Lastly, the kind of bugaboo topic.
Greg and Lane, are we stopping at 1? I want to be respectful of time.
Yes, we are over time.
Got it. Okay. I was like, I do not have time to go through this then.
All right.
For bonds.
Bonds are a thing. Call Joey with your bond questions. He would love it.
If you have a question, I'm more than happy to answer about bonds, but I do want to be respectful since I'm over time.
Sorry for taking so long to get through all this. It's pretty dense material. We are very happy that everybody tuned in today. If you have any questions, feel free to reach out to me directly. You know, we can send you the slides. You should have already gotten them from Lane earlier today. If you have a lot of dense insurance questions, make sure they all go to Joey. Have any softballs, feel free to tee them up to me. Otherwise, thanks for hanging out with us. Hope y'all enjoy the CLE, and we'll see you next time.